as I know that you all know, Lord Justice Bean is joining us remotely this morning.
Thank you. My lords, where we left off last night was at the conclusion of my preliminary remarks. The last points we discussed, as my Lord Fraser asked why we were looking at systems duty cases. Lord Justice Patten and I discussed the fundamental change that occurs, that I say is necessary between the grant of limited leave and the destitution-based application. And my Lord Justice Bean, the last question was, but are we not looking here at the issue of the wrongful failure to lift conditions of no recourse to public funds? And I said these are points that I will be dealing with today. And what I say is the interesting, the critical matter at the core of this appeal is the submission by the claimants, the premise of their case, that there was, or should be, an anticipatory duty to the anticipatory duty. In other words, and by the time these individuals presented their change of circumstances to the Secretary of State, it was already too late for the Secretary of State to consider that position. They had already been placed in a situation of destitution, and therefore damages should run at the very latest from that point, because that is the point when the Secretary of State accepted that Destitution Act incepted. In other words, that's a submission not that an individual decision was wrongly taken, there was delay or wrong criteria applied, but rather a submission that the system failed. What is said that I am one of those vulnerable people in a position where the Secretary of State needed to have a system in place from the point in time when I was granted limited leave to remain, to ensure if there were vicissitudes of life, if the partner that I applied with is no longer my partner, if the job that I applied with is no longer my job, if a child comes along, there needs to be a system in place that deals with my situation even before I bring my individual circumstances to your attention. And on that submission, Limbuela itself is against my learned friend, because as we looked at the passages yesterday, the references are Lord Hope, tab 6, paragraph 142, where he says, as soon as the asylum seeker makes it clear that there's an imminent prospect of breach of Article 3 conditions on the verge of reaching severity, the Secretary of State has the power and duty to lift. In other words, Limbuela itself gives the Secretary of State the chance to respond to the individual circumstances that are brought to the Secretary of State's attention. And then to the same effect, Lord Scott. Secretary of State cannot be expected to take action to relieve destitution until he knows of it. So insofar as Mrs. Justice May placed focus upon the notice requirement, she was not only right so to find, but she was also squarely in line with the ratio of the decision in Limbuela. But I will submit that he was also squarely in line with the recent jurisprudence on the cases where a systems duty can incept, and the classic Strasbourg cases where that has been accepted to be a duty that can bite at stages are one, the patient hospital cases, the prisoner, the person in immigration detention, the organization of the state by a dangerous activity that may impact on public. And as I will show you by reference to two cases, one either side of the line, this particular situation was nowhere near those circumstances. In other words, the degree of autonomy that an individual enjoys at the point in time where, applying the themes of these biographies, person is entered on a visitor visa, person subsequently says, can I now have leave, regularize my position? Person is granted leave with no recourse to public funds, person is able to work. That is not a situation which, on the present jurisprudence, involves the inception of the assistance duty. First case I will show you is on the below the assistance duty line. The second MG is above. Other way around. First one, MG, I'll show you, is below the line. Second one, CSM, is above. And then thirdly, I will tell you why Mrs. Justice May was right to deal with the matter in the way that she did. If we start with MG, and this is at tab 22 of the authorities bundle. You will see that the background was an individual accommodated by the Secretary of State in a hotel, having already been assessed to be destitute and in need of accommodation. Again, we know from Linguela, in a position where the individual is not permitted to work fend for themselves. Stabbing, injuring the individual occurs in that accommodation. An investigation is sought. And the basis for seeking that investigation, and I'm looking between D and E here, under Convention of Fundamental Human Rights and Freedoms, that Article 3 obliged the Secretary of State to initiate such an investigation because she had arguably breached one or more of her positive obligations under Article 3. In particular, the claimant contended that the Secretary of State had been under a lower level systems duty to adopt administrative measures to safeguard against inhuman or degrading treatment, under an operational duty to take measures to avert a real and immediate risk of inhuman degrading treatment from the criminal acts of the third party. And the Secretary of State's contention was that no such duty arose. And this case is helpful, the judge found, because it provides a seminal overview of the ways in which the Article 2 and Article 3 obligations can bite in circumstances where the individual is relying either upon a suggestion that the system is unlawfully at risk, or that the operational response placed them at risk. And what is said at paragraph 5, this taxonomy, the language that would be used would be systems obligation, operational obligation, and investigative obligation. And my lords will see that that matches the Strasbourg guideline that we looked at last night. Now, on the systems obligation, it's a very high-level obligation. The state must put in place a system to protect life and safeguards against inhuman and degrading treatment. That operates at different levels. At the high level, must be effective criminal law provisions to deter offences, police force to investigate. And then at a more granular level, which is the level that we are at here and the level that the judge was at in MG, lower level duty to adopt administrative measures to safeguard life. Such administrative measures are required in the context of any activity to which the right to life may be at stake. It's honor yildiz that is in the bundle, that is the municipal waste facility that was liable to a methane gas explosion. And then in particular, the lower level duty arises whenever a public body undertakes, organizes, or authorizes a dangerous activity. then it also arises, I'm looking 4 lines down, in cases where a public body is responsible for the welfare of individuals within its care and under its exclusive control. Contexts in which such additional measures are required therefore include hospitals, that's the example I gave a moment ago, detention, mentally ill persons, immigration removal centres, military operations, dangerous industrial activities such as operation of waste collection sites, safety on board ship. In tab 9, where the lower level systems obligation arises, the public authority must implement measures to reduce the risk to a reasonable minimum. Now, the way that that plays out in practice is seen in MG subsequently. And you'll see the submissions made. Paragraph 47, the Secretary of State at E. Submission was that the criteria for the imposition of lower level systems duty are not met, she says, because the claimant was not being held in detention on circumstances akin to detention. And
Sorry,
then
where are you now?
I'm at page 787, paragraph 47, next to
Oh yes, sorry.
in paragraph 49, consideration of the systems duty. It said that the fact that Ms. Lang identified systemic issues does not mean that the defendant is arguably in breach of the systems duty. And then the criteria I examined over the page. First one is whether the dangerous activity criteria for imposition of the duty applies. The second one is whether the exclusive control criteria applies, and that is, the point is made that the claimant and Mr. Adam were not under the defendant's exclusive control, they were not in detention. And then the crux of the reasoning of Mr. Justice Johnson is found just above on the page, paragraph 51, when he says that I was not shown any previous case in which the court has considered whether the lower level systems duty should apply in the housing of asylum seekers in private accommodation. Of course, to observe, these are individuals who've already been assessed to be destitute and in need of such accommodation. It's therefore necessary to determine whether the facts of the present case give rise to such a duty, particularly having regard to the categories where lower level systems duty have been held to apply. It's necessary to determine 1, whether the activity was inherently dangerous, 2, whether Mr. Adam and the claimant were under the defendant's exclusive control, 3, whether the defendant was otherwise responsible for the health and welfare of Mr. Adams and the claimant, and 4, whether the categories within the lower systems duties should be expanded to accommodate this case. And then in terms of the conclusions, paragraph 57, conclusion is the case does not fall within any of the existing categories where lower level systems duty has been found to exist. It's clear from the authorities that the categories are not closed. And over the page, paragraph 58, at a very general level, it is clear that the duty is imposed where it's necessary to give effect to the obligation under Article 2 to ensure that lives of everyone within the jurisdiction are protected by law. This discussion of Raybone, and I pick it up just above D on the side note, that emphasizes the importance of individual autonomy, which ordinarily weighs against the imposition of such a duty. It means that the individual is not able fully to exercise the autonomy justifying the imposition of additional duties on the state in that context. Those in the care who are very young and those without capacity are likewise unable to fully be responsible for their own well-being. Where someone embarks on a dangerous activity, they are reliant on the responsible for the activity to ensure that they are conducted safely, and on the state to ensure that there is a sufficient regulatory framework. The removal or curtailment of individual autonomy, considered in a broad sense, seems to me to be the underlying theme that explains the imposition of the lower level systems duty. And then on the facts of the case, here there was no relevant removal of the claimant's autonomy, that of Mr. Adam. Neither of them was reliant on the defendant for their own well-being. Everybody is at residual risk of violent criminal activities of other. The risk that materialized in this case was no different in principle from the risk that might otherwise impact on anybody. The risk engages the high-level system duty to maintain laws that deter and penalise offences against the person. Where the risk materialises, the state provides a general system of compensation. So that's the system duty. Then, next step, and this will be a theme of all these cases, next step then is to consider, was there a breach of the operational duty? That follows immediately, paragraph 61. The key question there is, was there an indication that Mr. Adams posed a real and immediate risk of harm to the claimant or anyone else? On the facts, that was negated. But just to emphasize why I'm showing you this case, because it reflects the reasoning of the judge. What she did is she looked initially whether this was one of those cases where a systems duty could be imposed, and then she went on to consider whether it's one of those cases where the operational duty arose because the individual had put their circumstances in front of the Secretary of State and the Secretary of State hadn't.
But we saw that yesterday, didn't we, in her judgment?
Second case on the other side of the line, CSM, that is in the bundle, the very case before, tab 21. Background circumstances can be summarized very briefly. The individual was detained in an immigration facility. Concern was expressed that the claimant had gone without his HIV antiretroviral medication for 4 days. I'm looking at page 751, the first 4 lines. The grounds of the challenge were that the necessary medication in detention had not been put in place and that an effective framework for the protection of detainees with HIV had failed to be implemented. Particularly the British HIV Association guidance had not been followed. And then what's held allowing the claim was one that in order to show a material breach of the duty under Article 3 and the Human Rights Convention, the claimant did not have to show that he had actually suffered serious harm as a result of the breach, but the lack of harm could mean that there was no right to damages. There was no reason why a more stringent test ought to be applied under the systems duty in Article 3. And then 2, that owing to the nature of antiretroviral treatment and the dangers of interrupting it, the possible consequences of the interruption were sufficiently serious as to engage Article 3. And where the judgment is particularly helpful is on 753 at the outset, where paragraph 9, the overarching issues are identified. 1, was there a systematic flaw in the defendant's arrangements of detention of individuals? It's the systems duty. And 2, in her treatment of the claimant, did the defendant breach the positive obligation under Article 3 referred to as the operational duty? The systems duty is summarized. Paragraph 11 requires the state put in place the appropriate legal and administrative systems for protecting those who are vulnerable to treatment, which would contravene the systems duty, and to take appropriate steps to become aware that person is at real and immediate risk of suffering such treatment, the operational duty. And then the judgment proceeds very much like the judgment that we looked at a moment ago in MG, page 760, paragraph 71 to 73. Looks at the systems duty. The state has a positive duty to put in place legislation and administrative framework to secure the health and well-being of those in detention. Falls squarely within the categories we looked at a moment ago to avoid harm of the kind which would engage Article 3. So that's analogous to the Article 2 duty, which requires health authorities to protect the lives of patients in a hospital. And then 73, the context in Savage was different, but the systems duty in relation to protection of immigration detainees from Article 3 treatment is of the same broad nature. And then you will see over in the following paragraphs, which I need not to take you through in detail, there was a finding of a breach of the systems duty because the hospital did not have in place guidance to deal with this situation. And then again on the same approach we looked at in MG, issue 2, the breach of the operational duty by failing to...
Where are you now, please?
I'm on page 763. just under paragraph 102, and then the next heading.
103.
Breach of the Article 3 operational duty by failing to provide medication until the afternoon of 11th of August 2019. And again, the summary is: in certain circumstances, the state owes a positive protection operational duty under Article 2 to protect individuals who are at risk of death or harm and sufficiently serious to engage Article 3. Raybone is cited, I'm looking at the first two lines of the citation. The operational duty will be held to exist where there has been an assumption of responsibility by the state for welfare and safety. And then 105, that duty will arise where there's a real, not fanciful, and immediate present continuing risk of the relevant harm. And then 117, a material failure was identified. I've shown you both cases, one on each side. But my underlying submission is that these individuals, persons who apply for leave to remain under the parent-child partner route on the basis of a condition of no recourse to public funds, do not approximate, in view of the autonomy they enjoy, ability to work, move freely in society, a similar status, and they do not satisfy the criteria for imposition of the system's duty. And my submission is that in the judgment of Justice May, she dealt with these matters exactly along those lines. She applied those principles, and looking at her judgment from paragraph 50 onwards, I'm at tab 13 of the core bundle.
13.
Tab 13. You see, first of all, paragraph 49, she summarizes submissions made but for the claimants. The thrust of which was, 4 lines from the bottom, he argued that Section 6 of the 1998 Act was engaged because the Secretary of State unlawfully prohibited the claimants from accessing welfare benefits, thereby creating conditions which put them in a position of destitution contrary to Section 6, the Section 6 obligation not to subject them to a risk of IDT. Once the Secretary of State's policy had put them in that at risk of imminent destitution, she was already in breach of her Article 3 duty to avoid IDT at the point where the person subject to the conditions experienced extreme destitution considering IDT. The Secretary of State comes under the operational duty, it's the second submission, to deal and remove IDT, but prior to this, and separately he argued, she was in breach of the procedural obligation to take active steps to avoid imminent destitution. Now, the judge's reasoning from paragraph 50 onwards was, first of all, that she identified the broad categories: systems, operational, procedural, investigative duties. She then correctly identified that what was in place here was a systems claim. To adopt the words of my learned friend in his submissions yesterday, the system placed them in a position of destitution. She then examined the way in which it was said that the claimant's Article 3 rights were breached. She identified correctly at the bottom of paragraph 51 that this was not an issue which had been determined by the Divisional Court in W. paragraph 52, she says first 4 lines, each of the mothers in the present case had no cost of public funds condition imposed on them. It was not suggested that the initial imposition of the conditions of that case was unlawful. Each of them in due course made a change of condition application, the condition to be lifted, and in each case it was lifted. 52 last 4 lines, the case is not put on the basis that any of the claimants has stated destitution to the point of IDT. Their case is that by operating a system found to be unlawful, the state failed adequately to protect them from the risk of becoming destitute, and that jeopardy alone entitled them to compensation. The case rests upon the argument that the Article 3 system's duty to protect against destitution arose from the time the condition was imposed, the condition of limited leave to remain. And in paragraph 54, the contrary submission is summarized that that would constitute a significant extension of the classes in which an Article 3 systems duty had been found to arise. The submission, I'm looking at the middle of paragraph 54, when individual is not destitute, imminently destitute, at the time of being granted limited leave to remain, it is not unlawful to impose a no cost of public funds condition. She says it follows, paragraph 55, there could be no violation of any Article 3 duty before the change of condition application has been made, bringing the circumstances of destitution, imminent destitution, to the attention of the Secretary of State. There's then the question of whether a violation occurs only upon IDT being sustained or whether it could arrive earlier.
Well, that last sentence is the answer to that is given in Limbuela, isn't it?
Yes.
Although she uses the word violation rather than breach.
Yes, which is why I submitted that honest application of Limbuela. The point of inception would be the point where the individual places, the change of circumstances places, the position they find themselves in front of the Secretary of State.
That may or may not be a correct way of summarising it, but the answer to that question is in Limbuela, isn't it? However one interprets the answer,
yeah,
that is the point in Limbuela.
yes. She then deals with a number of cases which are relied upon, and I can just endorse the conclusions there at speed. First, she finds paragraph 57 that Bogdanovich was a case of the investigative duty. That is correct. And then secondly, she considers D, and again, D is the case we looked at yesterday. The obligation there and the finding of breach was a failing adequately to investigate the activity of John Walboys. And again, as I conceded at the outset, in the case of the investigative obligation, there is a well-established jurisprudence of the Court of Human Rights that damages are available for anguish, frustration experienced by individuals in that situation. Because, as I submitted by definition, there will not have been an established breach. That's the point of the investigative duty. There will be an arguable breach. And then CSM, this is the case we looked at a moment ago, paragraph 60. That's the case where the system's duty incepted. And then Elias and Ahmed, she correctly decides paragraph 61, last 4 lines. The court's reasoning appears to be that it was information which gave rise to a procedural duty on Hungary to investigate the risk of treatment contrary to Article 3. So Elias and Ahmed, Bogdanovich, they don't give us the answer to this question. And then she deals at paragraph 63 with DMA. And DMA is the case that it is worth us looking at briefly, because claimant submission is that in DMA, the findings made and the situation was on all fours with theirs.
Which tab is it at?
This is at tab
16.
Thank you.
No, I don't.
16.
Looking at tab 16, page 501 is where it begins. And just to start with the regime in place in DMA, paragraph 12, page 510, in DMA, the threshold was not set at destitution or the provision of 4.2 accommodation, but conditions set out in paragraph 2, the provision of accommodation is necessary for the purpose of avoiding a breach of the person's convention rights within the meaning of the Human Rights Act.
But where are you reading from?
Paragraph 12 on page 510.
12.
Paragraph 34 to 36 sets the setting of the claims. And that was that the decisions of the Secretary of State acting by her officials, on page 514. These were cases where the Secretary of State acting by her officials had accepted that she had a duty to provide accommodation to DMA, AHK, BK, and ELN under Section 4.2 of the 2019 Act. And those the dates for those decisions are given. And then 35, criticism is made of the delay between those decisions taken that the individuals were in need of accommodation. Because they were both destitute and because their Article 3 human rights required it. And then there's a discussion of the times when accommodation was actually provided, 25th November 2019, 5 days after, and another case, 151 days after the first Section 42 decision. It said 36 charities, or sometimes friends, churches helped in the meantime. Help took the form of somewhere to sleep. Will inform the finding that there wasn't, in fact, any human degrading treatment suffered by these individuals. But you will see there's also then a discussion of just how vulnerable these individuals were. DMA suffers from rheumatism, paragraph 37, paragraph 38, AA had a chronic kidney disease. And it's in that context that the court... Okay. Apologies. AA we can disregard. This is not one of the Article 3 claims. But then 183, the conclusion is reached 541. The reference to context is, of course, particularly important, and paragraph 183.
183.
183. The reference to the context is, of course, particularly important in the present purposes. The context is that the breach of the Article 3 is imminent. The situation is best seen as one involving the prevention of inhuman and degrading treatment rather than simply a case of providing accommodation. In a particular case, before the decision is reached to accept the duty to accommodate here, there may be a question whether an individual is destitute or whether a breach of Article 3 is imminent. But at the point of the Secretary of State's Section 4.2 decision, made through officials, that question has been answered in the affirmative. So in terms of how that assists us with whether this case takes Mr. Goodman's case any further forward, these were cases which are post not only the situation being brought before the Secretary of State, but also post the Secretary of State having accepted the obligation accepted, and then delaying for significant periods for actually providing the accommodation relief sought. So whatever else, I'll be looking at DMA again when it comes to the additional ground. But in my submission, for these purposes, for the purposes of whether the system's duty, when that incepts, or the operational duty, DMA doesn't assist my learned friend no more than Lembuela does, because all DMA looks at is the obligation, breach of obligation, once the situation is brought to the attention of the Secretary of State, and moreover once the Secretary of State has accepted that the person is not only destitute but also in need of accommodation in order for their Article 3 rights to be met. The closest that my learned friend gets to any assistance from this case is that one of the defences, one of the mitigating circumstances brought forward by the Secretary of State was that accommodation was not readily available at that point. It took some time. The response to that was that that would not excuse the Secretary of State, because the Secretary of State needed to plan, monitor, have in place accommodation available for those individuals. But it is a separate question, and it doesn't avail the claimant in the course of vision. What I say is the fundamental extension that's being sought in this case, which is that the Article 3 systems duty incepts in respect of an individual who's been granted leave on certain conditions before that individual reappears before the Secretary of State to say that those conditions have changed. And my lords, it won't come as a surprise that I therefore fully endorse what Mrs. Justice May says. Paragraph 65 onwards of her judgment, I'm now page tab 13, page 138 of the core bundle, where she says...
We finished with DMA now.
I finished with DMA. Tab 13, 138, paragraph 65, persons with limited leave to remain subject to NRPF conditions are in a very different position to asylum seeker claimants in DMA and Venezuela, but it may properly be said that the latter restriction imposed on them have thrust them into a state of the latter, have thrust them into a destitution. The same is not true of the former class of persons, that is, those with limited leave to remain. They are entitled to work and provide for themselves. Most persons with limited leave to remain subject to NRPF conditions will work and never need state support, and that is the policy intention. But some may find themselves struggling, as these claimants do, and at that point, unlike asylum seekers, they are able to make a change of condition application to have the NRPF condition lifted. 2, second point, paragraph 66, it's the ability to work and apply is necessary to have the NRPF condition lifted. That's key when considering whether it is right to expand the class of low-level systems duties to encompass the duty to protect persons subject to NRPF conditions from destitution. And 3, this citation from MG, is whether there was a relevant removal of the claimant's autonomy. 67, unlike asylum seekers, the claimants here were able to work and could make applications for an application at any time. They were in no sense reliant on the Secretary of State for their own well-being. To adapt the above reasoning, losing employment or home or otherwise facing destitutions without state support is a residual risk which everyone faces. Whilst the categories of Article 3 systems duties are never closed, in my view, the claimant circumstances were not such as to call for an extension of the systems duty owed to them to the point of imposition of the NRPF condition. Now that, in my submission, is an orthodox and clearly correct application of the systems duty jurisprudence to the particular circumstances of individuals who are subject to the no recourse for public funds condition. And then, as in the cases we looked at a moment ago, of course, it's not the end of the inquiry, because individuals are still able to identify and complain of an operational breach. In other words, once I drew my attention to my circumstances to your attention, you didn't move fast enough. And that's 7172, where the judge concedes that, in her view, if the claimants were able to identify a relevant violation of their Article 3 rights, then they must show that the Secretary of State wrongly decided their applications to have NRPF conditions lifted. the risk of unlawful decisions identified by the court in W actually materialized, either because that change of conditions application was wrongly refused or because unreasonable delay in deciding it. And then she says, paragraph 73, the last line, it's impossible and would be inappropriate to lay down any hard and fast rule. And my lords, unless you have any questions on that aspect, which is ground 3, I can deal with the other grounds more quickly. Ground 1, claimant is misdirection of the procedural duty. I have 3 short points to make. 1, this is not a procedural investigative obligations case. The War Boys case, we looked at a moment ago, alias Nahmed, failure by the authorities to examine circumstances of IDT alleged by the proposed returnees. Those were, and Mrs. Justice May directed herself to the correct question, which is whether the jurisprudence on systems duties or operational duties assisted these individuals. And then thirdly, on the misdirection of the procedural duty aspect, insofar as my learned friend relies upon Limbuela, the speeches of their lordships are against him because they say in terms that the Secretary of State cannot be expected to act until he knows of the position the individuals find themselves in. And my lords, that was in the context of somebody who wasn't permitted to work, somebody who didn't have the possibility of maintaining themselves on their own 2 feet. And even in that context, in Limbuela, that was the earliest the obligation accepted. Now, my lord had a particular query on Limbuela. Is this an appropriate time for me to seek to answer it?
Is that yesterday or today?
Earlier today, a moment ago, when
I didn't have a query on it. I simply asked you if that the answer to that particular paragraph of Mrs. Justice May's, the answer was in Limbuela.
Yes.
Because it seems to me she says exactly, or she's dealing with exactly the point that was decided in Limbuela. It was paragraph 55. And the point at which, as she put it, a violation occurs, and Limbuela, Lord Hope and the other justices say, lords say, breach. But it's the point at which the breach arises. That's dealt with in Limbuela, isn't it?
Yeah. And as I indicated yesterday, there can and would be no resistance to a declaration in those circumstances.
Yeah.
The question at the heart of this case is whether on top of that there is then an entitlement to damages.
Yeah.
And that's the additional ground I'll be looking at.
I think we do appreciate that distinction, because that obviously is dealt with in Limbuela. The point of the time at which the breach occurs is clear.
Yeah.
It's whether one would be entitled to damages rather than a declaration as unto unlawfulness.
Yes.
Yeah.
And my lord, in a way, for the damages aspect, my submission will be that one is looking at 2 different facets here. One is breach on the part of the public authority, which gives rise to declaratory relief and entitlement to declaratory relief. And then the question of whether, in consequence of that, there was a breach of Article 3 of the entitlement not to be subjected to inhuman and degrading treatment. The last ground I have to deal with, ground 2, which is the submission misdirection on the findings in the claimant's case in paragraphs 51 and 52 of Mrs. Justice May's judgment. And for that, I'd invite you to turn to the four bundle and to look at the way that this aspect was put by the claimant. And that's at page 275, paragraph 73. And the defendant's position is criticized in two ways. Firstly, reference to risk of unlawful outcomes and more than minimum number of cases is criticized.
Can I just check I've got the right page? I'm very sorry. We're on 275 in the core bundle.
In the core bundle.
Which paragraph?
73.
73.
And then secondly, B, it is said it is unnecessary for the lead claimants to establish every application NRPF scheme was unlawful. The lead claimants have established that they come within the category of individuals for whom the defendant's policy created a risk of imminent destitution, and to whom the defendant was obliged to respond by proactively avoiding the risk of treatment contracts. Article 3, the NRPF scheme, the defendant's operation of it, unlawfully failed to comply with its obligation under Article 3. And this is the non-compliance which had a material impact upon the lead claimants. Breach of their procedural rights under Article 3 are made out. And then it said the Judicial Court did not require W to demonstrate infinite degrading treatment. And then to similar effect, paragraph 43 of the quantum submissions, that's C329 of the core bundle. Again, issue is taken with the defendant's case. It said the defendant's assertion, and look at paragraph 43, the defendant's assertion at paragraph 27 that the lead claimants had not proven that had they applied earlier, they would have established imminent destitution sooner is irrelevant. The lead claimant's case is based on the fact that the defendant had set the threshold for lifting the NRPF condition too late in order to avoid the risk of actual or imminent breaches of Article 3. And it's in that context, and Mrs. Justice May summarized the paragraphs 50 and 51 of her judgment at tab 14. Claimant's case to that effect. Yes. And again, paragraph 49, consistently with that, the summary of the submission is that the Secretary of State's imposition of the NRPF condition should expose the claimants to the risk of imminent destitution. And it's in that context that Mrs. Justice May found that in order to found a violation Article 3, she needed to do one of two things. She needed to find that the application once made had been improperly refused, or that there had been undue delay in the same. And then just so I've also referred to the skeleton argument on appeal, you find that at tab 15 of the core bundle. Paragraph 30, in summary, Article 3 ECHR, as incorporated and applied domestically, imposes not only a prohibition on inflicting inhuman and degrading treatment, but a proactive duty on the defendant to avoid the risk of an imminent breach of Article 3 in circumstances where its deliberate acts are liable to create conditions that breach Article 3. Failure to discharge that duty is said to give rise to Article 3 breach. And my lords, that's why I've called the submission a submission imposing an anticipatory duty prior to the anticipatory duty. In other words, it's being said the Secretary of State can be liable not only if he fails to lift conditions in time for inhuman degrading treatment to be sustained, but also for the risk posed by a scheme that he may not lift the no recourse to public funds condition at that anticipatory stage. And as I've said, there are cases where systems duty incept, which require the state to take those general levels, but depending on one's reading of Limbuela, this is not one of those cases. Now, in terms of what would need to be shown to make a good A claim that the system malfunctioned in the way suggested in W, the two matters which are very much in dispute. One, defendant says this is not a case where any of the claimants could not apply until they were destitute. And you have the wording of the policy at paragraph 42 of the, at tab 42 of the authorities bundle, as was then in place. That's page 1875. We looked at it briefly in the context of W yesterday, but it's appropriate to have the actual document referenced too.
Do you want us to go to that now?
Yes, tab 42, page 1875.
That's in the third Slim Authorities bundle.
Yes, it is. And you will see 1873 gives the date. This is the policy as in effect from the 10th of December 2019. And then what is said is you can exercise discretion not to impose or to lift no recourse to public funds. That's 1875, next to the underlining. Only where the applicants meet the requirements of paragraph Gen 111A and the criteria they're provided for is having provided satisfactory evidence that they are destitute, or there is satisfactory evidence that they would be rendered destitute without recourse to public funds. 2, having provided satisfactory evidence that there are particularly compelling reasons for welfare of the child. and 3 having established exceptional circumstances. And what I would underline there is that they would be rendered destitute without recourse to public funds. And then secondly, on that aspect,
When you say you mean it in the sense that that's in the future, is that?
yes,
Yeah.
yes,
But the issue on this policy was the imposition or the notification of a discretion.
yes,
That's
exactly.
why it was found to be unlawful in W.
Yes. Yeah. And we looked at the relevant passage, and yes, exactly, the divisional court, including my Lord Justice, being found, what that needed to do and it didn't do is emphasize to the Secretary of State that this wasn't a discretion, this was a duty. But for the more modest purpose that I rely upon it at this stage, and that is that it left the door open, there was a possibility of applying at the stage where a person would be rendered destitute without recourse to public funds. That is provided for. And secondly, for our purposes, there's also a provision made for particularly compelling reasons relating to the welfare of the child. And then secondly, linked to that, this is not a case where, in fact, the individuals were excluded from making good that particular aspect. Because, and I'll give you the references in the supplemental bundle, it's pages 158, 176, and 215. The applications were made on the basis that either they were rendered destitute or they would be rendered destitute without recourse to public funds. And I'll just show you one of those. 158.
Which bundle are we going to?
I'm on the supplemental bundle. And we're on the application form that has been incorporated within the bundle. 158. And right at the top of the page, the application is made on the basis that the applicant either is destitute or at the very least will be rendered destitute without access to public funds, and therefore also meets the requirement of the application to be removed. And my lords, that is why I say Mrs. Justice May was right. It's fine. In order to establish a relevant breach of the Article 3 duty, the individuals would need to show, it's been identified in W by the divisional court, that an application once made is not dealt with properly or is not dealt with sufficiently expeditiously, that materialized. There is nothing in W which found or held the policy was unlawful because it precluded applications made until that time. And my lords will recall there was a particular query still remaining whether in the cases of children there were other avenues potentially available. And my lords, that's somewhat at speed, the 3 grounds of appeal is there. Before I move on to the additional ground, is there anything that you wish to ask me about?
Nothing from myself.
No.
And my Lord Justice Bean doesn't have any either. So.
Thank you. The additional ground. On the additional ground, this is well travelled in the skeleton argument, and I have 8 short points to make. One, the starting point is the wording of Article 3 itself, purposes of a damages claim. We looked at that yesterday. The short wording is no one shall be subject to torture or inhuman and degrading treatment. These individuals have not been found to have been subject to such treatment. They've not been found to have sustained harm, which Article 3 is designed to protect them from. And in those circumstances, in the ordinary course, declaration is sufficient. My submission, Article 3 does not, on its face, envisage damages claims for a risk that might have happened in the future but didn't materialize. And moreover, as the wording of Article 3 suggests, the important point is to establish a IDT, inhuman degrading treatment. It is not worded referenced to destitution. And insofar as the Secretary of State imposes a less onerous application threshold, and that is met, my submission that simply doesn't answer the question of whether the individuals have a threshold of IDT or such sustained IDT. 2, Article 41, not in the skeleton argument, but you find it set out in full at paragraph 84 on page 21 of the respondent skeleton argument. I'm going to take you to that at this stage. That's sort of the reference point. It refers to just satisfaction being awarded to the injured party. And again, my submission is reference there is not to a party that might have been injured or might have been at risk of injury or might have been at risk of breach of the anticipatory duty prior to injury. 3, presidential practice direction. That's at the authorities bundle, tab 44, page 1890. We're in the 3rd Flynn bundle. I'm looking at paragraph 2. Paragraph 1 may be the most appropriate starting point. The awarding of sums of money to applicants by way of just satisfaction is not one of the court's main duties, but it is incidental to the task under Article 19. 2, emphasize the purpose of the court's award under Article 41 of the Convention in respect of damage is to compensate the application for the actual harmful consequences of a violation. No award can therefore be made for damages caused by event situations that have not been found to constitute a violation of the Convention. Paragraph 5, just satisfaction is afforded under Article 41 of the Convention so as to compensate for the applicant for the actual damage established in consequence of a violation. It's the same effect. 1890 over the page, paragraph 9, it's for the applicant to show that pecuniary damage has resulted from a violation alleged, not a potential violation alleged. A direct causal link must be established between the damage and the violation found. Paragraph 13, 3 lines down. Among factors considered by the court to determine the value of such awards are the nature, gravity of the violation found, its duration, and offence. There are several violations of protected rights.
Is it pretty much in line with the dicta of Mr. Justice Green as he then was in the 2015 case of the Warboys case?
Yes.
Really?
Yeah.
I mean, he summarises it in a way which I don't think is controversial and is generally accepted as being correct.
Yes. 4, domestic authorities. Ponderance of the domestic authorities, I'll look at GMA in a moment, support Secretary of State's position. CSM, we looked at earlier, paragraph 170, declaration only was made. And it's expressly said whether actual serious harm sustained be relevant to damages. I'll give you the declaration. In the single case, that point has been argued, HJA, which we looked at the outset of my submission. That was expressly the approach taken. In a moment. And then in AO 18682, this is tab 18, individual released from detention without provision of any provision being made. And turning to, may just be worth turning to the relevant passage. It's at page 683 of the authorities bundle. Paragraph 259, halfway down the paragraph, where in that context, individual released from immigration detention, no accommodation provision made, damages claim rejected because secondly,
I'm sorry, did you say page 683?
I'm on page 682.
Oh, 682.
Yeah, paragraph 259.
Yeah.
Looking 5 lines down, secondly, in any event, the facts asserted by the claimant do not amount to a sufficiently serious conduct to fall within Article 3, in terms of treatment of the Secretary of State or the consequences of treatment of the claimant. There is no reliable evidence that the claimant was in fact ever street homeless. He was sofa surfing, even if the claimant spent the nights occasionally in a park that did not meet the high threshold of established breach of Article 3. There's no evidence that he ever spent anything more than a short and foreseeable finite time without somewhere to stay. It's explained above. The facts are nowhere near resemblance in seriousness of those Ametsky and Libuela. Five, the answer to the question as to whether actual or substantive breach is required of the convention provision or not is not found. My learned friend suggests it's in section 8.1 of the Human Rights Act. And again, we're now tab 1 of the authorities bundle. Rather, first volume of the authorities bundle.
Page 15.
Page 15. Because what Section 8 provides in general terms at subparagraph 1 is that in relation to any act or proposed act of a public authority which the court finds is or would be unlawful, it may grant such relief, remedy, or make such order within its powers as it considers just and appropriate. So that is the umbrella enabling provision. But it doesn't in terms deal with the actual criteria by which damages may be awarded. That is set up paragraph 2, where damages may be awarded only by a court which has the power to award damages or under the payment of compensation in civil proceedings. In paragraph 3, no award of damages made unless taking into account the circumstance of the case, including any other relief, consequences of any decision, the court is satisfied that the award is necessary to afford just satisfaction. And then 4, the court must take into account the principles applied by the European Court of Human Rights in relation to the award of compensation under Article 41 of the Convention.
In a way, part of the difficulty of this preliminary issue is the wording of 8.3, because no award of damages is to be made unless taking account of all of the circumstances of the case.
Yeah.
That's a mandatory requirement.
Yeah.
Before you can award damages.
Yeah. Which is why in my submission, I'm conscious that this is a case which will give guidance, which will cover some of the other cases. The really fundamental thing that needs to happen at the very outset is for the court to assess. This may be where, this is the point that my Lord Justice Patten picked up early yesterday. Fundamental starting point must be that the court looks at whether this individual has actually sustained inhuman and degrading treatment. That will be such a key consideration. The overall global assessment that Section 8 requires as to whether an award of just satisfaction is necessary. And my Lord referred to Mr. Justice Green's decision that we looked at yesterday. I needn't take you to it again. Those cases, of course, fall into a slightly different category in terms of the identification of inhuman and degrading treatment, because those cases were concerned with the investigation.
No, I referred to it just in terms of the way you were taking us through the principles of the European Court Practice Direction,
yeah,
which was effectively covering the same ground.
I accept that. And my Lord, nothing that I say should detract from the principle that in the investigative duty cases, an individual doesn't have to show that a substantive breach of the same provision. Six, DMA, which is the case at the forefront of my learned friend submission, is not a case in which the point that I'm submitting has been argued. The Secretary of State did not submit in DMA that actual IDT was a requirement for a award of just satisfaction. The only case, aside from this one, where the point was argued that the parties have identified in some 48 authorities, tabs in your bundles, is HJA. But in any event, DMA was, as I've shown, a very different case. It is a case where the imminent IDT, the breach of the human rights condition requirements, was a key factor, was the criteria by which Section 4.2 support was provided. That had been accepted, and thereafter extensive periods where the individuals, the vulnerable individuals, were left in difficult situations. It doesn't, in my submission, provide an authority for individuals in these situations, which were very widely, to have an as-of-right automatic one-size-fits-all award in compensation. Still less does it justify an award on the notional basis that it can run from the moment that destitution was shown. 7, I just wish to refer to, and I've shown you, 2 cases decided by the Strasbourg authorities very quickly, because on their face, they are against me. They are Mokrani and Butt. Mokrani is tab 29. We're now in the second volume. This was a case of proposed enforced removal contrary to the Article 8 entitlements of the applicant. I'm looking at, it starts at 1373, just very quickly the background, paragraph 17, deportation made. To date, the deportation order against the applicant had not been enforced. Applicant commenced a relationship after the deportation order was made. In 3536, the court found that the facts, especially the intensity of the applicant's personal ties with France, were sufficient to enable the court to rule that deportation order were to be enforced. It would not be proportionate to the aims pursued. 36, therefore, in the event of enforcement of the order of Mr. Mokrani's deportation, there would be a violation of Article 3 of the Convention. 41, applicant claims £30,000 for non-pecuniary damages. He claims that his damages all the more significant as he's had to start his family life in conditions of extreme anxiety. In 42, there was no point taken by the government. The government simply considered that although non-pecuniary damages could be compensated, the amount claimed was excessive, offered €2,500, and €2,500 was awarded.
This was the heroin trafficker.
Yes.
Person, yes.
Yeah. The point was not contested in that case, and query whether spending family life in conditions of extreme anxiety for a protracted period under deportation order, whether that came close again to the substantive breach. Then, but is the second case, that's tab 33. This was a case where, again, deportation from Norway, 1527, paragraph 16. This is the case where the removal was only stayed upon interim measures having been applied for and granted under Rule 39, at the very cusp of deportation. Other developments, paragraph 41, including arrest of the applicants in an apartment, with a view to that. In paragraph 91, the court concluded that the applicant's deportation from Norway would entail a violation of Article 8 of the Convention. In paragraph 95, the court considered that the applicants must have suffered anguish and distress, and that there was a direct causal link between this and the matter. Potential violation of Article 8 of the Convention, and this prejudice cannot be compensated solely by citing Macroney. And then on an equitable basis, the court considers it reasonable in circumstances to award an award of €3,000. My lords, I've spared you a third one. There is a third case, which is to do, lots of Turkish claimants who were on hunger strike. It was proposed to re-detain them, and some of those received damages too, even though they weren't actually re-detained. The principal reason I haven't put it in front of you is it is in French language, and it would have stretched my linguistic abilities to their very limit. But for these purposes, I accept that there are those cases. But my submission is that on the principled approach, and on the approach that follows the practice direction, the better view is that damages are available under the Convention for individuals who've actually, under Article 3, who've actually sustained inhuman degrading treatment. The eighth submission I have is that it's not possible to circumvent that problem, as the judge at first instance thought one could, by relying upon authorities dealing with the investigative obligation. Because for the reasons I set out earlier, they're dealing with a different aspect, and they are dealing with cases where there is not going to be a substantive breach necessarily, but there is a breach of the individual's entitlement to have an investigation looked into. And for the frustration, etc., that follows from that, it is well established that damages may be awarded. My learned junior makes a point, which I'm happy to pass on, that the cases we looked at a moment ago also predate the practice direction that we looked at, which...
the two European ones?
Yeah.
Well, I think the practice direction is 2022, isn't it?
2007. 2007, I think is the first one. The one we have, let me just get...
The one we've got is much more recent than that.
Yeah.
It's updated regularly, I'm sure.
Yeah.
That was part of the reason I asked you about if you were quibbling with any of the analysis in the 2015 war-based case, because The practice direction covers fundamentally the same ground and approaches it in the same way.
Yes, and I think in an earlier round of this litigation, we did have the earlier practice direction in the bundle, but I accept that. So where that leaves this claim, my solution is that this is just as I was right. Find that this is not one of those rare cases where the jurisprudence on systems duty applies. As I've shown you, this is not a case where the individuals were treated unlawfully by the grant of limited leave to remain, nor is it a case where they were unable, by reason of policy, to bring their applications. Instead, it is a case where we can and should examine the Secretary of State's response to these applications, both as regards substance and as regards any contentions of delay. My submission is that it would be a significant extension of the principles outlined in the jurisprudence, both under systems duty and under limbuela, to impose a duty ante to the bringing of the individual circumstances to the attention of the Secretary of State. Then thirdly, on the damages aspect, I endorse the approach of the court in HJA, which is that in order to make good a claim for just satisfaction, fundamental starting point is an examination of whether the individual has in fact sustained inhuman and degrading treatment. And then, as I submitted below, insofar as you were against me on that, then at the very least, an in the round assessment would need to be made of the nature of the breach, of the consequences. There would need to be circumstances drawn to the Secretary of State's attention. Or what isn't permissible in my submission is the types of damages award that proceed completely independently of the inhuman degrading treatment requirement. My lords will have seen just how close to the line cases such as DMA were for those purposes. My lords, those are all the submissions that I have. I've made better progress than I envisaged. One possibility there is, and I've discussed this with my learned junior, is if you had any queries or would be assisted on any of the Secretary of State's position on the individual claims, he has some things he can say about those. We do have that window of time if you'd be assisted by it.
I don't think I have people arguing. No, I don't.
I'm just going to ask Lord Justice Bean if he would like us to rise for a moment or two, or if we can't actually hear at the moment, you may be on mute.
Still on mute?
I think in the circumstances, we might just rise for for 2 minutes so that we can communicate with the President of our Constitution, for which arrangements have already been made, and will come. Certainly for myself, I would not necessarily be assisted, and my Lord Justice Patten wouldn't be either, but obviously we'll decide that collectively.
Thank you.
So if it won't be very, very long, I'm sure. So. Just subject to a confirmatory point, really. Your generous offer of Mr. Tabori taking us to the details of any of the individual claimants, which we might explore, that was not being proffered in terms of seeking some sort of a knockout blow on any of the individual cases, was it? It was more just to give us assistance if we would like to examine the facts of any particular claimant's individual circumstances. Is that right? Have I understood you correctly?
Yeah, and on all the individual cases, you will have seen that there was the acceptance that the individuals had met the requirement.
Let me just check with the tech. We've still got Lord Justice Bean, do we? Do we still have Lord Justice Bean?
I've emailed them, so I'm waiting for it.
I think it looks as if we might have lost our
link.
president. Let's just pause for a moment while we see. Did we close the link? The link didn't get closed.
Sorry, that's out. Did you talk to us?
But on the mobile, on his mobile.
I assume it's an issue on his side.
Do you think he's...
authorised for electing.
Yeah, well, we certainly won't be doing it for 15 minutes, but let's rise and then go and call him. Hope, can you connect him from here? You connect yourself, do you know?
I can contact the person that's responsible for the IT.
Yeah, get them down straight away. We appear to have lost our president through a technical issue. So we're going to rise and try and have that resolved. So I can only apologise. If you could all please just stay in court. Hopefully it won't be very long.
Sorry about that. Someone's on their way to criticize this one.
Just by way of update, everyone, Lord Justice Bean will be joining over the phone shortly.
Hello.
Hello, sir. Can you hear us okay?
Yes. Can you hear me?
We can hear you fine, thank you. I will let the Constitution know that you've joined. Thank you.
Good.
Court raised.
So we have Lord Justice Bean attending audio only. We do have a...
Hello, everybody. I'm sorry about the technical difficulties, but I suggest that since I know what Mr. Taman and Mr. Goodman look like, and they know what I look like, it's provided that I can hear what's going on and ask questions if I have any, that the visuals are less important.
Excellent. All right. So just in order to make sure that your last point wasn't lost to the three of us, because it was at about that time that we had the technical issue.
Yeah.
You had, I think, just explained that you were not proffering Mr. Tabori's assistance on any of the factual aspects of any of the individual claimants, because you were in some way seeking some sort of a knockout blow or something like that. It was being proffered as a means of assistance to us if any of us would find it useful for the purposes of the appeal to examine each of the factual circumstances in detail.
Yes, the idea is because this is a judgment which may have wider reach, it would be a chance to highlight just some of the themes which
I understand.
come up.
Well, I think speaking for the three of us, because we discussed it before we had the technical issue, we are not inviting you to do that.
I'm grateful. And let me just make two corrections to make sure that I don't overstate my case. One of them, the first is that at the very outset of my submissions, I indicated that two of the claimants were receiving Section 17 support. It's in fact, I've rechecked it, one of them that was in receipt of that.
Yeah.
The case with B, and the reference is supplemental 344. And then two, just so you have the complete sweep on this, in the bundle you have the December 2019 iteration of the policy, which incorporates the wording destitute or would be rendered destitute. There were earlier iterations They are set out in W. They didn't contain that very wording. They have wording reference generally compelling circumstances relating to the welfare of a child. The reference on that is 478 to 479. But just to set the December 2019 policy that is in the bundle in that context. And then one thing that I didn't address and can do in a sentence is the submission was made that there were difficulties in leaving the judgment of Mrs. Justice May,
Mrs. Justice
May as the guideline in the county court. And my submission on that is that it gives the parties the steer they need, it permits to be done what needs to be done, that is the requisite in the round assessment if the claimants wish. The one marker it does set is that it states that the obligation in respect of which damages may be claimed is one that incepts at the point of time when the applications are made.
When the application
Are made. That is the lifting of conditions application. In other words, the Secretary of State isn't in breach prior to that point, prior to those circumstances having been brought to the Secretary of State's attention. That is, I hope, repeating a submission I made earlier. I say that's the indication.
Thank you very much. And on the basis of that, Mr. Tabori, do you follow?
No, nothing else. Thank you.
Well, by way of reply, I want to return to the fact that this is an appeal which revolves around the preliminary issue, and to get back to trying to understand what it was that the preliminary issue was designed to determine, because that will set the context, in my submission, for the distinctions that the court has been engaging with as between the question of breach under Article 6 and the question of when and under what circumstances just satisfaction might be awarded under Section 8 of the Human Rights Act. Mr. Patten, my learned friend, took the court to the claimant's skeleton argument for the trial of the preliminary issue in the course of his submissions, and that's a helpful place to understand how the argument was put to the county court. That begins at page 254 of the core bundle, and I'm not going to go back to many documents, but if we could just turn this one up to start, you can see how the issue was put before the county court. So page 254 of the core bundle. And the first most relevant paragraph is paragraph 3. So having set out the preliminary issue that was directed by His Honour Judge Cotter, the claimants then say at paragraph 3, the term procedural rights is used to distinguish breaches of Article 3 resulting from the defendant's breach of her procedural duty to act prospectively to avoid inhuman degrading treatment, as opposed to a breach of the substantive prohibition in Article 3 on inhuman and degrading treatment. So it's focused directly on breaches in each case. The trial of the preliminary issue is to thus test the contention of the claimants they're entitled to damages pursuant to Section 8 in respect of the state's failure of its duty to act prospectively to avoid a breach such that their corresponding procedural rights under Article 3 were breached. As is self-evident from the claim terms of the judge's direction above, the trial of the preliminary issue is about a question of legal principle as to whether damages pursuant to Section 8 can flow from a violation of procedural rights. It's consequently not concerned with evidence as to whether the matter of fact has substantive breach in a given case. And then moving forward to paragraph 41 on page 266. The claimant set out the application of the legal principles, which will now be familiar to the court, and explained that each claimant was granted leave to remain subject to a NRPF condition Each became destitute as a result of being subject to the condition. Each made a change of conditions application to the defendant on the basis they were destitute, and then subsequently, D, the defendant lifted the condition on the basis that the relevant claimant was destitute. So it was then explained that 42 and 43 says at 43, in the light of D, it's beyond dispute the defendant accepted each claimant was by the latest destitute at the point of step C. And the argument then at 46 and 47 explains the nature of the limbuela duty at 46. The Article 3 duty is one of the defendants making. The lead claimants were placed in this vulnerable position due to the defendant's deliberate policy choice to impose by default NRPF conditions on their LLTR. Defendant did not have to impose that system, but she chose to exercise her powers in that way. Where the defendant's actions put the claimants at imminent risk of destitution in return of Article 3 breaches, she was pursuant to Article 3 and Section 6 under a positive duty to ensure there was a mechanism to avoid such risks. And at 47, halfway down, it says that misunderstands the nature of the breach due by the defendant. Once the defendant's policy had put a person at risk of imminent destitution, the defendant was already in breach of Article 3, duty to avoid a risk of inhuman treatment. At that point, the defendant came under an additional duty to repair the damage. So it's still put in both ways, that there's the limbuela duty, and then once the application is made, at that point, the defendant comes under an additional duty to repair the damage as fast as possible. For any period of delay, whether an hour or a month, was already a period in which the defendant was already in breach of his duty. So they're applying the DMA approach that after the applications are made, you have to move very fast because by that point you're already in breach of the limbuela duty. And then 48, again, it's all about the 5 lines down. There can be no dispute that the breach occurred at the point of application because by that point the defendant accepted in each case the destitution threshold had been met. In fact, it's obvious in each case the point of destitution was in fact reached earlier than the date of application, but for the sake of simplicity in establishing the breach of procedural rights, the claimant choose the point at which there can be no logical dispute as to destitution having been reached.
Well, you explained this all very carefully yesterday.
Indeed, and I'll finish on what we then say in the conclusion at 80 on page 277. Invite the court to decide the preliminary issue of law, and then at 81, this trial is concerned with a point of liability rather than quantum. However, if the court finds that the claimants on the availability of damages for a breach of procedural right of Article 3, the claimants invite the court to give appropriate directions for the determination of quantum at a hearing should the matter not be settled. So that's what the judge did. So the preliminary issue was all about, is there a breach? All of the matters that come within the ambit of Section 8 under the question of are damages necessary to afford just satisfaction were for a separate hearing and a separate judgment.
Yeah, but all on the basis that what you were seeking damages for was breach of, if it's the right term, systems duty.
Well, no, I don't think that is the right term, my lord, because we've always put it on the basis of what we've just called the limbuela duty. The systems duty is precisely the boxing excercise that led Mrs. Justice May into the difficulties.
Let's not go down that. However you want, however it's appropriate to describe it. The preliminary issue was framed and was intended to determine whether your clients could get a remedy, I'll put it in those terms. I mean, you were actually seeking damages and you got damages for a breach of that duty in circumstances where they did not have to show that it led to a breach of their substantive Article 3 rights. In other words, they didn't have to show that at some point down the road they became subject to some form of IDT.
Yes,
I mean, yes, of course, they had to show destitution, but that's different, as we know.
Yes, that's right.
Yeah.
And so, my learned friend's been quite frank in finding it very difficult to find any case that supports the contrary proposition to that you do have to show IDT in order to establish damages. And so he's gone through a panoply of cases where a remedy, whether it be damages or not, is awarded for procedural breaches. What he hasn't done is given any authority for the contrary proposition that where there isn't a substantive IDT finding, that damages cannot be awarded or a remedy can't be awarded for that matter.
Well, he came close to accepting a remedy by way of a declaration, could
Indeed. But that, of course, assumes a breach.
Yes.
So it all comes under the Section 8 question of what is necessary for just satisfaction,
Yeah.
which is a subsequent question to what the trial of the preliminary issue was all about, which is there in principle a gateway into the remedy under Section 8?
but entwined within any public law claim for damages is for a breach of Article 3 is whether damages are required, well, whether just satisfaction requires an award of damages, doesn't it?
And I completely accept that position, my lord, and that's really at the heart of the distinction that I'm trying to draw, because that is then a question of judicial discretion. Now, my learned friend tries to elevate the instances where the court gives just a declaration to some sort of principle.
No,
But there is no principle that only a declaration follows unless you show IDT. There's no case that's ever said that. It's a matter for judicial discretion as to whether a declaration is sufficient. So look at CSM, Mr. Justice Bourne's judgment. He gave only a declaration having found a systems breach and an operational breach, i.e. two species of breach that did not require proof of inhuman or degrading treatment. He says, I'm going to make a declaration. But he does so as a matter of judicial discretion, not because there's some principle that that's all he's entitled to do. And so all of my own friends' arguments go to the way in which the judge, in truth, exercised his discretion. But that element is not under challenge, because they appealed that to Mrs. Justice May. She said, if I was wrong on breach, I wouldn't have challenged the exercise of the Section 8 discretion, and there's no cross-appeal against that component. So he's trying to shoehorn the whole Section 8 argument into what is in fact in front of the court now, which is a Section 6 question of breach. So I can, with that setup, address virtually the majority of my own friend's submissions, because the only point at which he demurs from that is where he tries to bring in his additional ground, i.e. the cross-appeal. But even there, even on the cross-appeal, he is derogating from the purity of his position and saying that the remedy is declaration. He's not saying that you can't find breach on the basis of procedural breaches. So I will be quick on all of these, but I'm going to just take up so I'm not going to take up the authorities, but I'm going to refer to the ones my own friend referred to. He took the court to MG, Mr. Justice Johnson's systems duty case at tab 22, in which the learned judge found no breach of a systems or operational duty. But there's no question there about the existence of those duties. So it's a case that is against the proposition that one needs to find IDT in terms of the basis on which the decision was made. He says, well, I've addressed this, he says that MG reflects the reasoning of the judge here. That goes back to my submission that we shouldn't be boxing it up into attempts to call this a systems duty, operation duty, etc. But even if we were, that would still involve the fundamental concession that the point about whether you need substantive breach is in effect unarguable. CSM, Mr. Justice Bourne's I've just addressed. Ilyas and Ahmed, that's tab 39, page 1742. I refer the court to paragraph 137 in that judgment. So Ilyas and Ahmed, I know a friend referred to, is a case of the Strasbourg court, and it's an important decision on the
tab?
Sorry, tab 39 in bundle 2. it's an important decision about the non-return principle in Article 3, and was the basis of the recent Supreme Court case in Rwanda, in the Rwanda cases. And so the court will obviously be well aware there's a long line of jurisprudence going back to Soering, S-O-E-R-I-N-G, about how Article 3 encompasses a procedural dimension of not returning people to countries where they may be tortured by a third party. Now, that's just yet another illustration of how you can have a procedural breach of Article 3. And Ilias is one such case where Hungary sought to return people to Serbia without examination of the merits of their application. And if the court looks at 1693 H7, in the absence of examination of the merits of an asylum application, it cannot be known whether the persons to be expelled risk treatment contrary to Article 3 in their country of origin. And then it goes on to say at the bottom of that holding, a post factum finding that the asylum seeker didn't run a risk in his country of origin if made in national or international proceedings cannot serve to absolve the state retrospectively of the procedural duty described above. And that is reflected at 137. So if the court just reads 137, that's the key point there on page 1742 of the bundle. And then what the court does at paragraph 255 on page 1764 is award the claimants €5,000 in respect of non-pecuniary damage. So the real relevance of this case is that these claimants did not suffer IDT, but were awarded non-pecuniary damages in respect of the procedural breach of their rights. So it's another case that illustrates the principle not only that you can have a procedural breach, but that you can have damages in just satisfaction for that procedural breach. It's completely contrary to the submission that only a declaration follows unless there's also proven IDT. And this is a leading case at the Grand Chamber recently, and recently relied on in the Supreme Court in this, in this jurisdiction. And so DMA, my learned friend, Mr. Justice Robin Knowles' decision, is simply an application of this well-established line of jurisprudence that you do not need to show IDT, and that where you do not show IDT but you demonstrate a procedural breach, just satisfaction can involve damages. Mr. Justice Robin Knowles awarded £1,000. So there doesn't seem to be any attempt to argue that DMA is simply wrong, but that is the only basis on which the Secretary of State's contentions could logically succeed. What the defendant tries to draw from DMA are various factual distinctions about, well, these were near the point of destitution. At one point it was tried to argue on the facts. But all of that, any factual distinctions, would in any event all go to the Section 8 exercise as to whether to grant damages as a matter of just satisfaction. So nothing to do with the question of breach, for which DMA is a strong authority. So turning then to my own friend's point on ground 2 and the way Mrs. Justice May addressed that, that's dealt with in my skeleton argument. But the point was that he supported her contention that this claim would involve what she called a significant extension of the system's duty. But I reject that articulation, both of this as a systems duty case as she understood it, but also as any extension whatsoever of the systems or the procedural duties within Article 3. This is simply an application of, as all cases are, to a set of facts that arises, which is obviously not entirely identical to every previous case, but it's pretty close to DMA, W, Limbuela, sufficiently that one can see how the principles should be applied. My own friend tried to characterise what we are arguing as an anticipatory duty to an anticipatory duty. First point about that is, again, there's no attempt now to argue that there is no anticipatory duty. Again, answers the preliminary issue. What the Secretary of State's now trying to do is make a subsidiary argument about where that would go on the details. Again, in my submission, all of that would have gone to the Section 8 judgment made by the judge below in the county court. And I just asked the court to reread paragraph 60 of W, which in any event answers the argument that this is an anticipatory duty to an anticipatory duty. My own friend said that a distinction between a whole bag of cases on procedural duties, hospital cases, prisoners, immigration detention, and organisation by state of dangerous activity, was that those cases are nowhere near the circumstances of these cases, because there was in those cases a degree of autonomy issue, which is differentiated here on the facts. My lords, again, I submit all of those matters go to the Section 8.3 exercise that was for the judge in determining whether or not damages were necessary to afford just satisfaction. The arguments on knowledge have been fully ventilated. If the court does go down the line of looking at what analogies can be drawn from systems duty and operational duty cases, then it needs to be recognised that at a general level, the generalised knowledge that one sees referred to in systems duty cases, the defendant was fully aware of the consequences of subjecting claimants to this administrative system of denying them benefits. And that's the very reason that she adopted a policy that said they could apply to remove the condition when they were destitute. It's just that the policy they adopted didn't achieve compliance with their legal obligations, but it wasn't because there was some lack of generalised knowledge. So I come to what the court might do on its judgment. If the court supports my primary analysis that there was here a breach of duty of the limbuela kind, or a species of that, following the line that the county court judge took applying the authorities, it would clearly find also that the preliminary issue is decided in the claimant's favour. There was a breach of duty under Section 6. And my primary submission is the court should then say, well, the judge dealt with the questions under Section 8. The court below in the High Court found no cause for complaint with those. There's no dispute taken with the judge below. It's Justice May's determination of that. And so the county court's order can be restored. As a matter of practice, that it may be helpful then to send the matter for further case directions, but as a matter of practice, as I accepted yesterday, for these claimants, that would bring an effective end to their proceedings, and they'd seek to wrap them up. If the court wants to do that itself, if it was possible, fine. Otherwise, we'll go and deal with that in the county court or High Court below.
Well, Mrs. Justice May has, one of her orders was to transfer it to the district registry, I think.
Yeah, so back to Bristol District Registry.
So that wouldn't be back to the judge who done, unless he has the necessary authorisation, it wouldn't be back to the same judge who did the quantum analysis.
Not necessarily, although I believe that judge has a Section 9 authorisation now, so it could be.
So it might be a distinction without a difference. Yeah.
Can you just so we're absolutely clear, I mean, she rejected the argument that you're putting now. So she set aside the judge, the county court judge's award of damages, but sent it back. Now, I think it's clear from her order that she anticipated that there will be further proceedings in these
Yeah.
cases. Now, is that, I'm not absolutely clear what those further proceedings are. I mean,
No.
if you're, if the position were to remain that her decision, or at least the substance of the effect of her decision stands, it goes back for what purpose?
Yes. So I also don't understand what we were supposed to do. What I thought was left open, in substance, what Mrs. Justice May decided was the preliminary issue in favour of the claimant's arguments that they had a procedural right.
Yeah.
And she said, but what you have to prove is that the applications you made were wrongly decided or took too long.
Yeah.
What I would seek to argue if we were sent back to do so on the basis that Mrs. Justice May decided the claim was that on the facts, the Secretary of State took too long. And we would say, see for in particular the DMA case. But I think my submission is this court can cut through that, because if you look at the way Mr. Justice Robin Knowles did it, he said, in cases in front of me where the people were already destitute and the way the system was operated was you could only attempt to lift you can only attempt to get support to lift your destitution at the point of destitution, so mirroring the situation here. The Secretary of State had to move really fast to determine those applications in the Section 4 asylum seeker context that was before him. And he said, I don't need to get into the detail of whether 45 days or 155 days was too long.
No,
on any view.
I know, but with respect, I'm not sure you're answering my Lord's question. We know how Mr. Justice Robin Knowles dealt with it. In terms of the procedural future of this case,
Yes.
You're saying if you had to go back with Mrs. Justice May's judgment being remaining as it is and not overturned, you would seek to argue it
That
took
point.
too long.
Yeah.
Quantum of damages isn't an issue anyway. At this point, and you said there's a way this court could cut through
That's
that.
what I was about to get to. Sorry, my
Well,
Lord. I didn't.
Your enthusiasm for
So the way it would cut through is to say, on any view, 40 to 62 days, which is what we're dealing with here, was too long. So even on Mrs. Justice May's approach, there was a breach of duty. If it was 2 days, 9 days, 2 weeks, whatever the Secretary of State should have been allowed to consider the applications, in reality that makes no difference to the breach. The quantum of damages was so small that it wouldn't have made any real difference to the way in which the judge assessed quantum. And so there's no point in realistically going through that exercise a second time, and the court could just uphold the quantum decision as...
But the quantum decision's not under appeal, so it's not a question of us upholding it.
Well, the court would just say there's no need to revisit that in the light of the precise formulation of the nature of the breach that this court identifies.
What she envisaged, as she made clear in 71, 72, is that if the breach and the entitlement to damages doesn't run from the point that the successful application is represented, the claimant could still say two things. One, when I made an application, it was wrongly refused, therefore I should have damages for that. And two, after I made the application, you took too long. And those were the two issues that she referred to.
Yeah. So just to come back to so if the court goes with the primary submission that the judge was right, obviously that's very neatly resolved. If the court says there is a procedural right, but it involved demonstrating too long, then the court can either send it back or say that's unnecessary because we've got a sufficient overview that we can save that further stage of quantum argument. If the defendant is right and we have to show IDT, then send it back and we'll try and show IDT. So those are the main three outcomes. Well, can I just take a moment with my
By all
junior, and
means.
if there's anything else the court wants to ask, otherwise I'll. No, my junior has nothing to draw to your attention. So well, those are my submissions in reply. Unless there's
Well, let me just check over the audio link whether my Lord Justice Bean has any questions for you.
I have no questions. Thank you all very much. I heard you loud and clear once I was back on the audio link. If my colleagues have no questions for you, then I can say from here we will reserve judgment, hand it down in draft in the usual way. As counsel well know, but I'm still required to say it in every case. 2 points about the hand down. First of all, it's sent out in draft not for re-argument, but for correction of typos and any obvious factual errors. Secondly, that there are obligations of confidentiality as set out by the Master of the Rolls in the Counsel General for Wales's case. Clearly, the claimants can be told the outcome, and members of the defendants' legal teams and anybody else who within the defendant departments who needs to know in order to give instructions on the case. In case of any doubt, consult my clerk or the Civil Appeals Office. I hope that covers everything. Thank you both, and both leaders and your juniors and backup teams for the helpful presentation of the case. And I think that concludes the hearing.
Yes, indeed. Thank you all very much.